LLP.
Hello and welcome to the Disability Law Q&A with me, Martin Willemse. I'm a partner at the firm of Sanfiro to American LLP. We've got offices in Alberta, Ontario, and BC and represent clients with disability claims, critical illness claims, life insurance claims, and other insurance claims throughout Canada other than in Quebec and the territories. I'm the Western Canada practice leader and welcome all questions submitted via social media platforms today. One of the things that have come up more recently, and there's still some aspects of it that are unknown, I suppose, would be the Canada Disability Benefit. This has been the topic of a lot of discussion over the past few years. It has made itself through the government channels and is now in operation. Lots of people who have been approved for the disability tax credit or will be receiving, already have, or will be receiving letters from the government to advise them that they may apply for it. So there are some questions regarding this benefit. I'll give some preliminary information. As far as we understand it, it is a $200 per month benefit that is paid. I believe it's non-taxable. The criteria would be that to apply, you must be between the ages of 18 and 64 to apply. The benefit itself is supposed to provide some income, financial support to people who have a low income. So it is a staggered benefit. It depends on how much money you are making annually. And if you exceed a certain threshold, the Canada Disability Benefit may be reduced. The criteria, as I understand it, would be that, as I said, you have to be between the ages of 18 and 64 to apply. You must be a Canadian resident, and you must have filed a tax return in the previous tax year. Also, most people, and I think the criteria may change at some point, but for the moment, it is if you have been approved for the disability tax credit, then you may be approved for the Canada Disability Benefit. The big question, of course, as with all these things when we speak about disability claims, is would the Canada Disability Benefit form an offset from LTD policies? Our position would be, of course, that it should not be. Having said that, it is so new, we're not sure how insurance industry will respond to it. Having said that, the idea behind it is that it is a supplemental income. It is supposed to supplement those with disabilities who have a low income threshold, to add to their income, to alleviate poverty, and to assist people with disabilities to have some financial support. So the idea behind it is that it should supplement other benefits and should not be deducted from other benefits. So we'll see how this plays out in time. But if you have further questions regarding this, or if you find that insurance companies try to deduct it, then of course we're open to having a discussion about that. And that leads to another question, I suppose, which would be the CPP disability benefit, which is a benefit that has been long-standing. Now, we speak about this on our radio shows, on our TV shows, and through these platforms. I've spoken about this before, but we'll just recap it again so that there is no confusion as to the Canada Disability Benefit. These are two different benefits. CPP disability benefits are paid also by the federal government, and it is available to people who have contributed to the CPP plan. The criteria would be that you must have a condition that is both severe and prolonged to the extent that you cannot work in any gainful occupation. They usually look at what the prognosis is. So if the prognosis is positive, you likely will not be approved. If the prognosis is guarded or unknown, and it depends on the factual circumstances with respect to the medical evidence, you may be approved. The Canada Disability Benefit is different from this, of course. I don't think it requires you have to make contributions to the CPP plan. With the CPP Disability Benefit, that one is taxable. It has an annual increase. Usually, under LTD policies, the annual increase is not an offset. In other words, it's not a direct deduction. With CPP disability benefits, if you have dependent children, you may be applying for them as well, and they may be able to get a child benefit. Under LTD policies, usually the CPP disability benefit as the prime benefit is a direct offset, where children benefits or dependent benefits are what is referred to as indirect offsets. So there's a different calculation that is made, which means that it's not a dollar for dollar offset. It all depends on the wording of your policy. Why do people speak about this in the context of LTD claims? LTD policies, as I said before, usually have provisions that allow insurance companies to deduct the CPP disability benefit. And some policies go so far to say that if you do not apply, the insurance company can simply estimate the amount and deduct it in any event. There are benefits to getting the CPP disability benefit approved. One of them would be that the government has accepted that you cannot work in any gainful occupation. Under the LTD policies, usually there would be an own occupation period and an any occupation period. So your argument would be, when you get to the any occupation period, that even the government accepted that you cannot work in any gainful occupation. The CPP disability benefit, as I've mentioned before, has a cost of living allowance built in, and those increases usually are not deductible under the terms of group LTD policies. So you may be getting more money over time. There's also the child benefit that I've referred to before. You also want to apply for the disability tax credit, which is another form of benefit that you may be able to get, which would allow you some tax savings, considering that the CPP disability benefit is a taxable benefit. So that's some preliminary information with respect to the Canada Disability Benefit, and just a little primer, rehash of what the CPP Disability Benefit entails. If you've got questions on that, you're welcome to contact our firm. As I said, we've got offices throughout the 3 provinces of Alberta, British Columbia, and Ontario. As you can see on the screen, you can go to disabilityrights.ca for any information, for more information. If you've got questions, you're welcome to reach out. So the first question today is from Ziggy Smitanka. I hope I pronounced that correctly. Ziggy says, I've been on LTD for over 3 years now. My insurance provider sent me on a few medical expeditions under the pretext that it was to help me, but it turned out both times it was an attempt to help their bottom line. Now they want to send me to a third. These have all been detrimental to my recovery. Just when I feel I'm starting to recover from this, meddling causes my condition to roll back every time. Can I deny this new request to see their high gun? How do I make this stop? Under the terms of a disability policy, the insurance company will have provisions that would allow the insurer to have you attend examinations when the insurance company deems it to be fit. Now, my position on this would be that it would have to be reasonable. So it depends on the conditions that you have. It also depends on whether they've already had you assessed by someone. And it sounds like you've already gone through 2 of them. If you have a physical condition and a mental health condition, and they may want you to do a functional capacity evaluation, it may explain why they are doing more than 2, but it's not common to have somebody attend. Usually when I get these files, when somebody contacts us and we're retained, I get a copy of the insurance company's file. And in that file, we will be able to see what has happened during the adjudication process. It may happen if it's a mental health condition that they may send you to a psychiatrist. If they then want to send you to another psychiatrist right after that, I think that would not be reasonable, because then it becomes doctor shopping. It depends on what the recommendations were that were made in that report. It depends on when the assessment was done. For example, if you had seen a psychiatrist and the person had made some recommendations in the report, and then a year later they want to send you to one again, depending on whether there has been further treatments that have been tried to just see what the new update is, that may be deemed to be reasonable. The question of whether you should attend, it all depends on the wording of the policy. If you refuse to attend, then the insurance company may say that you are breaching your obligations under the policy and they may terminate your claim. Then you're on the defense. I would like to have more information regarding what is being done here. Why? Who have you seen? When were you seen? What was their opinion? And what context is it that your condition has deteriorated? Because it then will be a discussion with your doctor, I think, if they are sending you for a functional capacity evaluation, for example, where you have a physical condition and that FCE, which is the acronym for it, has the potential of worsening your condition. In other words, if you attend the FCE, they put you through a battery of physical tests, and that actually worsens your chronic pain. Or if you've got chronic fatigue syndrome, it has the potential of worsening that condition as well. You would want to have your doctor put in writing why you should not be attending this assessment and explain what the risk factors are, so the insurance company can then hopefully back off and not do that assessment. But do remember that under the policy, they do have a right to do that. And if you refuse, you're at risk to the extent that they can terminate your claim. But it is also fact driven. It really depends on the circumstances. I am concerned that you've already attended two, they want you to attend to a third, but it depends on who these doctors are, what their expertise would be, and what conditions are being assessed. I hope that's helpful. And again, if you've got more questions, you're welcome to reach out to us. There's a question on YouTube from Town to Country Off Grid. Do you have to wait until you're denied before hiring a lawyer, or do you wait for a denial? You can speak to a lawyer at any time. At our firm, we offer free consultations. So as you've seen on the screen, you can go to disabilityrights.ca for more information. We offer free consultations to people who may have questions, especially in the context of a denial, or if there is a process that is being undertaken by the insurance company that may be of concern, or if you've got a general question. So you're welcome to contact us. We get involved once there is a denial, and we get involved by pursuing a legal claim on behalf of our clients, through which we try to get them the best compensation that is available under the terms of the policy. And our clients then focus on their treatment and hopefully to get better while not having to deal with the insurance company directly. So I hope that answers the question. If you've got more questions, as again, you can reach out to us. Ali says, I recently had to go back off on leave after I returned to work. I have a recurrence option in my coverage, but after 5 months, my insurer has not responded to anything I or my doctor have submitted. Is there an amount of time that is acceptable to wait for this? So let's just speak about the recurrence provision. Most policies provide that if you go off work and then you return to work full-time, but you go off work within the first 6 months after that full-time return to work due to the same condition, then you may request the insurance company to reopen your claim without having to go through a wait or do a waiting period again. So it's a recurrence of the previous claim, it just carries on. But if the insurance company is waiting 5 months, or you've waited 5 months for them to respond, that is an inordinate amount of time. It should not take that long. They should at least respond to you. So would there, under the terms of the policy, be a provision that would detail how long they have to respond? Generally, there isn't. But that doesn't mean that you would have to wait for them to respond until they've deemed fit. I would strongly advise that you be the squeaky wheel. Contact the insurance company again. Find out who the claims manager is. Try to speak to their supervisor or their case manager. Send emails, phone calls. Do that all the time until you get a response. If they still do not respond, then please contact our firm and we can speak to you about other options as well. The insurance company has a duty of good faith. These are peace of mind contracts, which means that they have to treat you when assessing the claim in an objective manner, but they owe you a duty of good faith, meaning that they have to address a disability claim in a speedy time frame, which means that if you submit a claim, they have to address it. If you submit an inquiry to reopen a claim, they should not ignore that. Obviously not. That may lead, depending on where this goes, to a damages component later on. But It all depends where this would go. Obviously, you want your benefit paid as soon as possible. So I would be, as I said before, reaching out to the case manager and also their senior or their supervisor or their manager, and even that business manager. I've got a question from Jonathan. Not sure how this came in. If I am currently off on disability, but I am diagnosed with a new condition that will force me to stay off on leave, how do I claim for this? Do I need to go back to work once I've recovered from my original condition? When you submit a claim for disability benefits, let's say you went off work because of anxiety and depression. The insurance company is now paying your benefit. That component may have started to improve, but you're still unable to work. Then you have a diagnosis of cancer. You go through chemotherapy, and that in itself is also creating other symptoms that did not exist when you had your anxiety and depression. All of this is happening while you're still receiving benefits because of your initial claim. Do you have to go back to work to reignite a new claim? No, you don't. The claim is being assessed on a month-by-month basis because your entitlement under the policy is based on benefits or on the evidence that is submitted at the time. Now, of course, there may be pre-existing condition exclusions, but that is a much more difficult discussion and complex discussion. Suffice to say that if your condition is such that you cannot work, diagnosis is important, of course, but functional restrictions and limitations, functional impairment, would be the most important thing when assessing a disability claim. So you have new conditions that have arisen, or you have conditions that may have been in place but have become more disabling since you've gone off work. You have to be assessed globally. So your function is assessed based on all your conditions, all your restrictions and limitations, and how they impact your ability to function in the workplace. So I hope that answers the question. You don't need to go back to work. Your new condition should also be assessed when considering whether you're disabled within the meaning of the policy. Manuel says, my sister just received a positive cancer diagnosis, is going to need time off. She has been on insurance for about 7 months, but started talking to a doctor 8 months ago about things. Will they deny her coverage because they may have had this technically before she was on insurance? Okay. So, firstly, my best wishes to your sister. What the question here is Manuel's sister has had coverage. In other words, she has been covered under the terms of the policy through the employer, I suppose, for a period of 7 months and is now going off work. The concern is, will the claim be denied because of what is referred to as a pre-existing condition under the terms of the policy? This comes up on a weekly basis. Insurance companies often deny cases because of pre-existing condition exclusions. The vast majority of group policies provide that there is some form of a pre-existing condition exclusion, but they all have different language. Insurance companies approach them differently. So, under the terms of a policy, let's just use as an example. The vast majority will provide that if you go off work within the first year of having coverage, then the insurance company will investigate whether your current disability is directly or indirectly related to a pre-existing condition. And a pre-existing condition may be, under the terms of that policy, a condition for which you receive treatment, medical care, during a specified period of time. As an example, some policies may provide that if you received medical care for a condition in the 3-month period before your coverage started, and that condition is directly or indirectly related to your disability, which arose within the first year of having coverage, your claim will be denied, excluded. Not all policies have the same definitions, of course. So in a situation like this, if your sister had symptoms, it depends on what the policy says. In other words, what I'm hearing or reading here is your sister had symptoms of cancer, saw a doctor in the month before coverage began, and she's going off work within the first year of having coverage. it very likely will be that the insurance company is going to investigate whether her condition is related to a pre-existing condition. And then the most important factor, the key factor here will be, what is the language of the pre-existing condition exclusion? Is it that if you had medical care, what does that mean? Medical care usually would also be defined. It would be something for which you were treated, or you consulted a physician, or for which prescription medication was given. Other policies may provide that if a prudent person would have seen a doctor during that specified period of time, that they can exclude it as well. So I'm sorry that your sister is going through this, but it depends on the wording of the policy and on the medical evidence and the facts of the claim. So I hope that is somewhat helpful to your question. Then there's a question on Reddit from Sanal. An external investigation confirmed I was psychologically abused at work in an unsafe work environment and that management was negligent in addressing the situation. I've also been experiencing health complications and have been told I cannot work. I've been off since last October because of stress and I have not been paid. WCB denied my claim. I'm waiting to hear back from my short-term disability claim. What should a person do in my situation? You should probably appeal the WCB denial because the policy will likely require you to take further steps. From what I'm reading, this is clearly related to the workplace. So the insurance company may look at this and say, well, this is a WCB claim, and or may say to you that we look at this as a workplace issue versus a disability. You say you've been off works because of stress. An external investigation confirmed I was psychologically abused. If your condition is such that you cannot work, then the right thing is to submit the claim to the insurer. You've submitted it for a short-term disability claim, so they may, well, so many things may happen here, that they may say that you applied too late, so that may be one reason. Or if they don't do that, then they may say to you that this is related to the workplace. Some policies do provide that if a disability is short-term specifically, if it is related to a workplace incident, then they don't have to pay it. Then there's also long-term. Long-term may say to you, and this is what I see so often as well, just like with pre-existing conditions, this comes up. When there is workplace bullying and harassment, you want to convince the insurance company how horrible it was, how bad it was, to convince the insurance company that they should pay the claim. The question is not how bad and how terrible and how severe the bullying and harassment was. The question is, are you unable, due to a medical illness, to perform the duties of your own occupation? Keyword, occupation, not job. So what many people do when they do this is they try to convince the insurer how bad that workplace was, to the extent that they now have a medical illness, a mental illness, that they cannot work. But if the situation is such that, yes, this was bad at the workplace, you now have a mental health illness, but if you're able to go work where the workplace doesn't have that bullying and harassment, it's a harmonious workplace, the bully, the harasser is not present, or you can go work at a different location or for a different employer, then the question is, are you able to do that? And if you say yes, as long as I don't go back there, then I should be fine to go back to work. It very likely is not a disability under the policy. So these are things to be considered. If you submit a claim because of bullying and harassment, consider, do you have the medical support that you have a mental health illness? What are the restrictions and limitations? And usually it would be things like panic attacks, social isolation, social withdrawal, inability to focus, concentrate, cannot multitask, cannot comprehend information, panic attacks, heart palpitations, poor sleep, oversleep, medications that impact your cognitive functioning as well. Consider all those things and then ask yourself the question, if I have all of these things, how am I going to work in a place where the bullying and harassment is not present, but I have to recover from the condition and the restrictions and limitations resulting from that condition? That is the way to approach this. So when you submit a claim based on that, have a discussion with your doctor. Does the doctor support that you cannot work in your own occupation? Not your own job, your own occupation, as that term is referenced in the disability policy. Because if you're going to say your claim is based on bullying and harassment because of this workplace, and it hadn't been for this workplace or the bullying and harassment, yes, you could go back to work. Your claim very likely is going to be denied. If that does happen, if you do have a denial, as I said before, you're welcome to reach out to our firm and we can offer to you a free consultation where we will assess the denial letter. We will look at the medical evidence, hopefully at the policy if you have it available, and discuss with you what your options are so you can make an informed decision as to how to proceed. Okay, then there's a question from Butlins. If your insurer says you are able to perform a job, even if it is not your own job, what are the limits to that? Can they expect me to take an entirely new career? Also, what if I decide to take on early retirement while on LTD? What would this do to my claim? Okay, so that's a lot. So let's look at this again. Go back to basics. You have a disability policy. The disability policy will have definitions for disability that you would have to satisfy in order to receive LTD benefits. You're asking whether the insurance company can push you to work in another job. What are the limits to that? And can they expect me to take an entirely new career? Under the terms of your policy, I'm going to speak in a general sense. So this doesn't apply to every single policy. It applies to the vast majority of group policies. There would be an unoccupation period. Usually it's 2 years, sometimes it may be 1 year, sometimes it may be 3 years, but usually it's 2 years. During that period, you have to prove that you are unable to perform the duties of your own occupation. Then, at the end of that own occupation period, the definition changes. Then you have to prove that you are unable to perform the duties of any other occupation. And that's where your question comes in. If you are unable to perform the duties of your occupation, for the first 2 years, of course, that's relevant. But when the definition changes, then it's no longer can you perform the duties of your own occupation. Then the assessment is based on your restrictions and limitations, considering those. Do you have the transferable skills, in other words, through your education, your training experience, to perform the duties of any other occupation that may pay to you a certain percentage, if there's a percentage given in that definition, or if there is no percentage, an amount that is roughly equal to your LTD benefit. So can they expect me to take an entirely new career? The question is, are you able to work in another occupation as that term is defined in the policy? So it's not expecting you to take on a career. It simply is, do you have the qualifications, the education, the training experience to work in another occupation that you could perform based on your functional restrictions and limitations, and they would pay to you the same as the LTD benefit amount? That's the question. What if I decide to take early retirement while on LTD? Early retirement, okay, another good question. Look at the terms of your policy. Some policies may provide that retirement benefits are deductible as offsets from your LTD benefit amount. Some may provide that it is a direct offset. Others may provide that it is an indirect offset. If you are entitled to full pension, even if it's early retirement, full pension, some policies may provide that if you are eligible to retire with a full pension, that benefits will terminate in any event. So, as you can gather from what I'm saying, reading the terms of your policy is key. You need to know what the policy provides for. Early retirement may terminate the benefit in any event, unless it is a reduced pension. Then you would make the argument you forced me, because of a denial, for example, to take a reduced pension. But retirement benefits themselves, depending on the wording of your policy, may be an offset. The retirement benefit itself may wipe out the LTD benefit. It may be bigger than your LTD benefit. All of these things, as you can hear from what I'm saying, are so fact-specific to each and every claim. The own occupation period sounds like it has ended. Now it is having a discussion with your doctor. Doctor, do you support that I cannot work in another occupation based on my transferable skill sets within my restrictions and limitations that would pay to me a certain amount of money? In other words, that would pay to me either what is defined in the policy if there's a percentage given. Some policies may say an occupation that may pay to you 50% of your pre-disability income or 75% of your pre-disability income. Other policies may not have a percentage at all. Then you default back to something similar to the LTD benefit. I know that was a mouthful, but there were a few questions there. I hope that was of help, Butlins. If you've got more questions, please reach out to us and we can review your personal circumstances with you. Look at the policy because that is key here, and look at what the medical evidence is and whether your claim is being denied. It may not be denied. They may be trying to provide you with some retraining. They're not obligated to do that, but they may be motivated to do that to get you work ready to go work in another occupation. You're very welcome. I'm glad that was of help. So, with all of that said, that brings us to the end of today's session. Our next session will be, I'll tell you now, an employment law Q&A, which is tomorrow, July the 9th. And that would be at 1 p.m. Eastern Standard Time with my partner, Lior Samfiru. Hope you enjoyed today's session and look forward to seeing you all again. Thanks. Bye-bye.